Good afternoon, ladies and gentlemen. Welcome back to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. Today we have both a plea and motion to revoke community supervision docket. And on my docket for today, under pleas are State of Texas versus Christopher Suarez, 635-930, represented by Miss Ashley Morgan. Miss Morgan, are you ready to proceed? Is Ashley or one of her attorneys with us?
Judge, yes, I'm ready.
Okay. And next one is cause 632-566, State of Texas versus Rolanda Davis, represented by Mr. John Perez. Mr. Perez, are you ready to proceed?
Yes, Judge.
Thank you. Next one's cause 657-103, State of Texas versus Nathan Rivera, represented by Mr. Joseph Stateson. Mr. Stateson, are you ready to proceed?
I am.
Thank you. Next one's cause 669-211, State of Texas versus Adrian Jackson, represented once again by Mr. Joseph Stateson. Mr. Stateson, are you ready on Mr. Jackson's case also?
Yes, Your Honor.
And we have motions to revoke community supervision or revoke deferred adjudication probation and then revoke community supervision. Starting with cause 653-313, State of Texas versus Daniel Espriella Castillo, represented by Mr. Flavio Hernandez, and Mr. Hernandez has been called into a felony court and will return. We have cause 658-142, State of Texas versus Michael Perez, represented by Ms. Suzanne Kramer. Ms. Kramer, are you ready to proceed?
Your Honor, she stepped out. She had a plea.
All right, fair enough. Next one is cause 647-640, State of Texas versus Jonathan Chavez, represented by Mr. Abel Dominguez. Mr. Dominguez, are you ready to proceed?
Yes, Your Honor.
Thank you. And we have cause 633-107 and 629-590, State of Texas versus Leroy Maldonado, represented by Mr. Randall Griner. Mr. Griner, are you ready to proceed?
Yes, Your Honor.
And we have cause 639-414, State of Texas versus Sergio Diaz, represented by Mr. Adam Flores. Mr. Flores, are you ready to proceed?
Yes, Your Honor, we're ready.
And last but not least, we have cause 635-213 and 674-124, State of Texas versus Angela Ravel, represented by Mr. Ross Brendel. And I guess the second case is a new case. It's not really something we're taking up today. Mr. Brendel, are you ready to proceed?
Yes, Your Honor.
Okay, well, we've got an interpreter. Let me punch my correct interpreter button here.
Judge, while you're doing that, may I give my spiel to the pleas, please?
Let me swear you in right now first, and then please do that. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Proceed.
This is for all the people that are doing pleas today. If your client is going to be residing outside of Bexar County or the state of Texas, you will need to advise the judge prior to making your plea. If you are placed on probation, you will be contacted by the probation department within the next 48 to 72 hours via either telephone, email, or text, and they will advise you when you need to attend your orientation. Should you fail to hear from anyone at the probation department by next Wednesday morning, you need to call this number. Attorneys, please write this down. 210-335-7446. You will need to call the probation intake department, and Ms. Benavides has put that into the chat section so you can find it. Call them, let them know that you were placed on probation today and that you need an orientation appointment. If that doesn't work, keep in contact with your attorney. Your attorney can reach out either to the court or myself, and we will get things straightened out. Does anyone have any questions? Good luck, everybody. Thank you, Judge.
Thank you. Representing the Bexar County Criminal District Attorney's Office or Assistant Criminal District Attorneys Ross Lewis and Eddie Villarreal in all matters. Okay, at this time we have our interpreter, who is Miss Narrow today. Is that correct? And we're ready to proceed. Thank you. We're ready to proceed on a motion to revoke. What is this one? Oh, excuse me. Motion to enter adjudication of guilt and revoke community supervision on Sergio Alvarado Diaz, cause 639-414. Is that correct, Mr. Flores?
Yes, Your Honor, we're ready to proceed, Your Honor.
Fair enough. This is cause 639-414, State of Texas versus Sergio Diaz. Once again, this is a motion to enter adjudication of guilt and revoke community supervision. At this time, Mr. Diaz and Mr. Flores, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both your signatures on it. In fact, Mr. Diaz, is this your signature on this document, sir?
Sí.
Thank you. And Mr. Flores, as attorney for Mr. Diaz, is this also your signature on this document?
Yes, Your Honor.
Next, I have two documents, one in English and one in Spanish. And these documents are entitled Trial Court Certification of Defendant's Right of Appeal. I note on my copy of the Spanish version of the Trial Court Certification of Defendant's Right of Appeal, the defendant's name is not properly inserted under where it says the State of Texas versus. So Pat, if you would administratively ensure that that name is entered before we process the documents in this case.
I will do that.
Okay, this document says Trial Court Certification of Defendant's Right of Appeal is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Mr. Diaz, is this your signature on both the English and the Spanish version of this document, sir?
Sí.
Thank you. And Mr. Flores, as attorney for Mr. Diaz, is this also your signature on both these documents?
Yes, Your Honor.
Thank you. Mr. Flores, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Correct, Your Honor.
Mr. Diaz, in cause 639-414 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir? And normally that would be either true or not true. And of course, we always accept true with an explanation or not true with an explanation.
Sí. Cierto.
Court will accept the plea of true with an explanation. Is that okay, Mr. Flores?
Yes, Your Honor.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Diaz's probation in cause 639-414?
Yes, Your Honor. Mr. Diaz reporting has been good up until December 1st, 2021, which is the last time we saw him. He did, however, miss his very first month of reporting. He is paid $1,008 towards his fees. He has a balance of $187, and he is currently delinquent $55. We have no record of any of his 36 hours community service having been completed at an acceptable location. Apparently, the defendant did, on his own, make a donation of $190 to the food bank. So we'll need to decide whether or not the honorable court wishes to honor that. He has had one positive UA for alcohol, 8 negative drug tests, and one, one sample was not able to be tested because he did not provide a large enough sample. He has completed DWI education, victim impact panel, and the CATSNP program. He is currently testing on Smart Start Mobile at 6 times per day, skipping 18 tests since the month of June. We have no recorded high BRACs. This is his 3rd violation report, 2nd MTR. His case expires April 3rd, 2022. His officers recommending that he be continued on probation, that he remain on a Smart Start mobile device until the end of his probation, and also to return to monthly drug testing. However, when I was writing up my synopsis today, I could find no indication that the defendant was ever placed on weekly drug testing. He has no criminal history.
Okay, defense, what are you requesting, Mr. Flores?
We're asking the court to follow the recommendation, Your Honor. My client, he doesn't do drugs, Your Honor, and he gave me his word that he doesn't drink no more since the violation. And we're asking the court to continue on probation, Your Honor.
I'm running out of options on the breath testing devices. We had him apparently on a Smart Start mobile device at 4 blows a day, and he violated, and he had a previous MTR, and we did not revoke him at that time and put him on 6 blows a day, and he's violated again, and now we have 18, is it 18 skips, Susan? Did I get that right?
Yes, 18 since the month of June.
So obviously we can't determine whether he's drinking alcohol or not if he doesn't blow into the machine.
Yeah, he's not like he's not drinking, but he's forgetting to blow. Like he's not the brightest.
And is Mr. Diaz out on bond at this time, or is he in jail?
No, he's in right now. Right now he's on bond, right, Your Honor, but he does have a warrant right now.
I got you. All right, state recommendation on Mr. Diaz, please.
Your Honor, state recommendation would be to change the device to the Scram device so that we can confirm whether or not Mr. Diaz is drinking for at least 60 days.
I have no objection, Your Honor.
All right, does Mr. Diaz know that a Scram cam device costs $350 a month?
Yes, Your Honor, he understands that, Your Honor. He has no objections paying that amount every month.
Okay. Mr. Diaz, it costs 639,414. The court accepts your plea of true with an explanation. I grant the state's motion to enter adjudication of guilt on the charge of driving while intoxicated. I find you guilty of the charge of driving while intoxicated. I sentence you to 6 months in the Bexar County Jail, probated for. How many months has he been on probation so far, Susan?
Judge, he was originally placed on probation in February of 2021.
Wow.
So he's been on 11 months.
I got you. And DWI Education, DWI Victim Impact Panel, Community Alliance for Traffic Safety New Intervention Program, all of which he gets credit for because he already completed them on the initial phase of this probation, I believe. 36 hours community service, he gets credit for 19 hours at $10 an hour. He's donated to the food bank. I suggest you counsel him on court charities, which do not include the food bank, but there's no problem with that. He's going on a Scram bracelet within 10 days. As soon as the Scram bracelet is active, he may remove the Smart Start mobile device. I'm very concerned about the cost of this. Mr. Flores, would you, you've confirmed for me that Mr. Diaz says he can afford a Scram bracelet. Now, would you?
Yes, Your Honor. He's currently working, Your Honor.
All right. So let me ask Mr. Diaz directly. Mr. Diaz, can you afford $350 a month for a Scram bracelet?
Sí.
All right, we're getting somewhere.
Judge, is there a time limit on that?
Not until I determine how well he does on the Scram device.
Okay.
Defense, you're welcome after 90 days to approach me and see if we want to come on something else. But we're
Yes, Your Honor.
see how
So
that
a
works.
minimum
May I
of
ask
90 days?
What the term of probation is? I don't remember.
I haven't announced that yet. We're getting there. We're going to do 6 months over 6 months. What was
Okay.
the original fine, Susan?
Let me get that for you, Judge.
Because he's doing well on monies, no problem.
I usually have that written down and I forgot. It is, original fine was $400.
$400 plus court costs, credit for any monies paid or any programs completed. I'm going to put him on weekly UAs. This is called weekly UAs. And after he shows me 4 clean weekly UAs, I'll put him back on regular monthly UAs. But I won't know he's done that, Mr. Flores. So you're going to have to remind me or remind the probation officer, okay?
Yes, Your Honor.
What did I miss, Susan?
I think that covers it, Your Honor. So you want scram for a minimum of 90 days before considering removal?
That's correct. Make sure your officers understand that's not 90 days and it comes off. It's 90 days and then I consider whether to take it off or not.
Right. They always send you a supplemental.
All good. All right, let me go through it one more time, make sure we don't miss anything. Mr. Diaz, in cause 639414, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated, first offense. I sentence you to 6 months in the Bexar County Jail, probated for 6 months, $400 fine plus court costs. DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, weekly UA, Scram Cam, ankle monitor within 10 days. Once the ankle monitor is active, you can turn in your Smart Start mobile device. Credit for all monies paid, programs done, or community service hours completed or donated for. Requiring substantial compliance within 10 days. Anything he hasn't done or signed up for, I want him signed up for it within 10 days. I think he's actually well on his way to doing everything correctly. So we're all good. We just stop drinking, we'll be fine. Anything further from the state of the defense of Mr. Diaz?
I just have some instructions for the defendant.
Go ahead.
As well as I.
Your Honor, may I ask you to recall the warrant, Your Honor?
Yeah, and we'll recall the warrant and any other pretrial bond conditions that were associated with this case.
Yes, sir. Thank you, Your Honor.
All right, Mr. Diaz, you will be receiving an email, telephone call, or text from the probation department advising you that you have to go to an orientation. You are starting all over. You must attend orientation to sign your paperwork. Failure to do so will result in a warrant being issued for your arrest. You will have the same officer that you have now. You can contact your officer when you get out of jail and keep in touch with them. They can give you the referral for the Scram device so that you can go over there and either get the device, excuse me, or get on the waiting list, because sometimes they do not have them readily available. Do you have any questions?
On the number, is it the 7446 number?
Yes,
No.
and it's in the comments.
Yes,
Okay.
I saw it.
And I also have instructions. Mr. Flores and Mr. Diaz, I will be sending you a new application for probation and data sheet.
Okay,
Sign that as soon as possible so that the clerks can send it to probation and then call Mr. Diaz to set up his orientation. So
great.
I'll do that now.
I'll do that right now.
Okay, thank you.
Okay, y'all are dismissed. Thank you for your help. Good luck,
Your
Mr.
Honor.
And Pat, is my understanding correct that we have only one other case that requires the interpreter, and that's Mr. Daniel?
Yes, Your Honor. And yes, it's Mr. Castillo and Mr. Flavio Hernandez is here and we can go forward.
Perfect. Mr. Hernandez, in cause 653313, State of Texas versus Daniel Espriella Castillo. Are you ready to proceed?
Yes, we are, Your Honor.
Wonderful. Let's do it. All right. This is cause 653313. State of Texas versus Daniel Castillo. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Mr. Castillo's and his attorney, Mr. Hernandez, signatures on it. In fact, Mr. Castillo, is this your signature on this document, sir?
Así es.
And Mr. Hernandez, as attorney for Mr. Castillo, is this also your signature on this document?
It is, Your Honor.
Okay, next I have two documents, and one is in English, one is in Spanish. The title of each entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And I notice administratively on my documents, once again, the Spanish version does not have Mr. Castillo's name spelled properly in the correct blank at the top where it says State of Texas versus. So Pat, if you would administratively correct
I
that
will.
before we process the paperwork.
Of course.
Otherwise, Mr. Castillo, is this your signature on both the English and the Spanish version of this document, sir?
Así es. Es correcto.
Thank you. And thank you. And Mr. Hernandez, as attorney for Mr. Castillo, is this your signature on both these documents, sir?
Yes, Your Honor.
Okay, once again, this is a motion to revoke community supervision. My understanding is this is going to be an uncontested motion to revoke community supervision. Is that correct, Mr. Hernandez?
Yes, it is, Your Honor.
Mr. Castillo, in clause 653313 on the motion to revoke community supervision, how do you plead, sir?
The verdad or true.
Thank you. And
¿Cierto?
thank you. Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Castillo's probation, please?
Yes, Your Honor. His reporting has been good. However, the last time we did see him was November 18th, 2021. He did not report in the month of December. His case is paid in full. He has completed all 36 hours of his community service, as well as DWI education and victim impact panel. However, we have no completion of the CATSNP program. He has had no positive drug tests, 6 negative drug tests. He is currently testing on Smart Start Mobile at 4 times per day and had 7 skips. He has no criminal history. This is his first violation report, first motion to revoke, and his officer is requesting that his Smart Start Mobile be increased to 6 times per day.
He's not blowing into it. So whether he's blowing 4 or 6 times a day, if he doesn't blow into it, that doesn't help us. Mr. Hernandez, how can we fix that?
Well, Your Honor, this is an unusual case. He's done a lot more than most of my clients do before they get an MTR. There's quite a long list of positive things he's done, but he's just frustrated, Your Honor, and he does not want to be on probation any longer. I am not totally in agreement with that, but I do believe he has the right to request time instead of probation. Considering all of the good things he's done and the 22 days jail credit he has, I would ask for JSET, time served.
Okay, and may I have your permission to talk to your client directly about this jail sentence request?
You have it, Your Honor.
Mr. Castillo, we don't like to put people in jail unless they really, really deserve it. And in my opinion, you don't really, really deserve it. You're asking your attorney to ask me instead of keeping you on probation. And probably the only thing I would change is put you on a scram bracelet at $350 a month for probably a minimum of 60 days to correct the fact you're not blowing in my machine. Otherwise, I would continue on probation if that's what you request. If you would rather do a jail sentence, I'm going to give you 60 days in the Bexar County Jail. The sheriff's quotient currently, in my understanding, is at least 2 for 1 and maybe 3 for 1. My ultimate goal is to give him approximately 30 days in jail in some capacity, which is what, and there's 22 days credit, of course, counts on that. Mr. Hernandez, what do you want to do? Do you want to stay on probation and get a scram bracelet, or do you want to go to jail? Or Mr. Castillo, excuse me. And Mr. Hernandez, if you'd like to go on a
No,
break.
yo me quiero quedar aquí, yo quiero cumplir aquí, porque así lo deseo yo quiero cumplir y quiero salir limpio de este lugar, porque no quiero volver a caer a esta cárcel jamás en mi vida.
He's been adamant, Your Honor. He wants to stay in jail.
Okay, so Mr. Hernandez, I didn't understand what his answer was. Did he want to continue to request a jail sentence?
Yes, sir.
Okay, state recommendation?
Your Honor, that was the first I'd heard of a jail sentence, so I would agree with the court and recommend a 60-day jail sentence.
And Ms. Gross, from the probation department perspective, what would be your recommendation to the court?
Judge, we would have no problem with the recommendation of or request of him doing his jail sentence, and his original sentence was 6 months. He did comply with a lot of the things, and so we would have no objection to a reduced sentence.
Okay.
And for your information, his original fine was $400.
Okay, and Mr. Hernandez, I'm going to ask you one last time, and I apologize, I'm beating a dead horse, but I want to make crystal clear to Mr. Castillo, since we don't speak the same language, that his request is 60 days in jail and not to be continued on probation with a scram bracelet. Because I don't want to put him in jail if he's willing to stay on probation and get a scram bracelet. So would you ask him
Thank
that?
you. Thank you, Your Honor. Thank you, Your Honor. Javier Perez, be quiet. Thank you, Your Honor. We want to stay in jail and get this over with. We do not want scram.
Mr. Castillo, on cause 653313, the court accepts your plea of true. I grant the state's motion pursuant to your request to revoke your probation. I sentence you to 60 days in the Bexar County Jail. It has a $400 fine plus court costs, credit for time served, time and money to run concurrent. My understanding is he has at least 22 days jail credit on his record.
Yes, Your Honor.
Benavides, does that sound accurate?
Yes, Your Honor.
All right. Good luck, Mr. Castillo. Thank you, Mr. Hernandez.
Castillo, 8 más días va a salir.
Gracias a ustedes y muy amables por su atención.
De nada. Gracias. Thank you, Judge.
You bet. Y'all are dismissed. And can we
Gracias,
cut our interpreter loose, Pat?
Yes, sir.
Castillo, thank you so much. You're excused.
Unchain her.
All right, let's get our pleas knocked out here. Let me do a little coordinating.
Judge, I'm going to step away for just a moment and get some hot tea.
Yeah, I'm gonna go off camera for 2 minutes so I can get my organizational skills.
I want to get rid of these frogs.
Okay, back on the record. Bexar County Court of Law number 6 in the Bexar County Veterans Treatment Court, Judge Wayne Christian. We have 4 pleas set for today. Cause number 635930, State of Texas versus Christopher Suarez. And Mr. Suarez is represented by, who we got here? Don't tell me, let me guess. Miss Morgan. And Miss Morgan, are you ready to proceed, please?
We are ready.
And next case is cause 632566, State of Texas versus Rolanda Davis, represented by Mr. John Perez. Mr. Perez, are you ready to proceed?
Yes, Judge.
And the next case is cause number 673075, State of Texas versus Nathan Rivera, represented by Mr. Joseph Stateson. Mr. Stateson, are you ready to proceed?
Yes.
And the last case I have in this batch is cause number 669211, State of Texas versus Adrian A. Jackson. Once again, represented by Mr. Stateson. Mr. Stateson, are you ready on Mr. Jackson also, sir?
Yes, Your Honor.
Thank you. The first document I'm looking at is entitled Defendant's Consent to Plea by Video Conference, which purports to have both the defendant and the attorney's signature on it. In fact, Mr. Suarez, in cause 635930, is this your signature on this document, sir? Mr. Suarez, I don't know if your microphone's turned off. I can't hear you yet.
Let me find him, Judge. He was at work, but he was available. Like, let me see where he is right now.
All right. So
He also needs to put on his video.
I told him.
All right, let me back up. So is he not online with us right now, so to speak?
I'm not
Here
sure.
he is.
Hello, I'm on.
Mr.
Put on your
Suarez.
video.
Thank you, sir. What I'm asking you, Mr. Suarez, if this is your signature on this document entitled Defendant's Consent to Plea by Video Conference.
Yes, sir.
Thank you. And Ms. Morgan, as attorney for Mr. Suarez, is this also your signature on this document?
It is, Judge.
Thank you. And Ms. Davis, in cause 632566, is this your signature on this document?
Yes.
Thank you. And Mr. Perez, as attorney for Ms. Davis, is this also your signature on this document?
Yes, Judge.
Thank you. And Mr. Rivera, on cause 673075, is this your signature on this document?
Mr. Rivera.
Thank you. And Mr. Statesman,
wait.
as attorney for Mr. Rivera, is this also your signature on this document?
It's my signature, but Mr. Rivera had not unmuted. Mr. Rivera.
Yes, hello?
Okay, there you are.
All right, Mr. Rivera, this is Judge Christian. Can you hear me, sir?
Yes, sir.
Is this your signature on this document entitled Defendants Consent to Plea by Video Conference?
Yes.
Thank you. And in cause 669-211, Mr. Jackson, is this your signature on this document, sir?
Yes, Your Honor.
And Mr. Statesman, as attorney for Mr. Jackson, is this also your signature on this document?
It is, Your Honor.
Okay, the next document I'm looking at is entitled Waiver of Constitutional Rights and Court's Admonitions that purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Suarez, is this your signature on this document in cause 635-930?
Yes, it is.
And Mr. Davis, or Miss Davis, excuse me, is this your signature on this document in cause 632-566?
Yes, it is.
Thank you. And Mr. Rivera, is this your signature on this document in cause 673-075? Can you hear me, Mr. Rivera?
Yes, hello?
Mr. Rivera, is that you? Can you hear me?
Yes.
Is this your signature on this document on your case? The document is entitled Defendant's Waiver of Constitutional Rights and Court's Admonition.
Yes.
Thank you, sir. And Mr. Jackson, is this your signature on this document, sir, in cause 669-211?
Yes, Your Honor.
And Mr. Statesman, we don't need you on this one. Thank you. By signing these documents, are each of you telling me that you've had enough time to either read these documents or have them read to you in their entirety? Get any questions about what was on these documents? Those questions were answered to your satisfaction by your attorneys. So that in signing these documents, you're telling me that you agree with and understand everything on these documents. Is that correct, Mr. Suarez?
Yes, Judge, that's correct.
Thank you. Is that correct, Ms. Davis?
Yes.
Thank you. Is that correct, Mr. Rivera?
Yes.
Thank you. And is that correct, Mr. Jackson?
Yes, Your Honor.
Ms. Morgan, as attorney for Mr. Suarez, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes to both, Judge.
Thank you. Same question for Mr. Perez with regard to Ms. Davis.
Yes, Judge.
Thank you. Same question for Mr. Statesman with regard to Mr. Rivera.
Yes, Judge.
Thank you. Same question for Mr. Statesman with regard to Mr. Jackson.
Yes, Judge.
Mr. Suarez, are you a United States citizen, sir?
Yes, Judge.
And same question for Ms. Davis.
Yes.
Thank you. Same question for Mr. Rivera.
Yes.
Thank you. Same question for Mr. Jackson.
Yes, Judge.
Thank you. Ms. Morgan, as attorney for Mr. Suarez, has the state fully complied with discovery for you on this case?
They have, Judge.
Thank you. Same question for Mr. Perez as
Yeah,
attorney for
Judge.
Ms. Davis. Thank you. Same question for Mr. Statesman as attorney for Mr. Rivera.
Yes.
Same question for Mr. Statesman as attorney for Mr. Jackson.
Yes.
Okay, let's see what we're doing on some of these. Hey, you got a motion on Mr. Suarez's case, it would appear?
Yes, Your Honor. The state will be adding account 2. I checked the information. There wasn't one originally filed, so we will be adding account 2 and then waiving, abandoning count 1 and proceeding on count 2, which is obstruction of a highway.
No objection from the defense, that will be granted. Let me do a little writing here. State's motion to amend the information, adding count 2, alleging obstruction of a highway. No objection from the defense is granted. Then state's motion to waive count 1 and proceed on count 2, obstruction of a highway. No objection from the defense is granted. Therefore, Mr. Suarez, in cause 635-930, the charge of obstruction of a highway. How do you plead, sir?
Guilty.
Is there an agreement for Mr. Suarez?
Yes, Your Honor, there is. It will be for 14 months deferred adjudication, a $600 fine, court costs, 48 hours community service, DWI education program, the victim impact panel, CATSNP program, and Smart Start Mobile for half the term.
And I'm noticing on your plea bargain, it talks about an ATP evaluation, but we don't use those because sometimes it takes a year to get that going.
Yes, Judge. It was the original offer was made when it was in a previous court, so we altered it.
Morgan, are you in agreement with that?
Yes, Judge, and I told him that he'd be doing a cat snip, so he's,
All right.
he's
Perfect. Okay, let's make sure I get this right. Mr. Suarez, in clause 635-930, the court accepts your plea of guilty to the offense of obstruction of a highway. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt, place you on 14 months deferred adjudication probation. That's a $600 fine plus court costs, 48 hours community service, DWI education course, DWI victim impact panel, community lines for traffic safety, new intervention programs, Smart Start mobile home interlock at 4 blows a day for half the term, which is 7 months. Anything further from the state or the defense on Mr. Suarez?
Yes, Judge. Mr. Suarez has had some slight issues on his bond conditions. He currently has a warrant active for his arrest. We were asking that you recall that.
Okay. On Mr. Suarez and everybody else, after we get our plea in there, we're going to recall all pretrial bond conditions and warrants, and we'll start over.
Thank you, Judge.
All right. Good luck, Mr. Suarez. Thank you, Ms. Morgan. Y'all are out of here. And let's see what we're doing with Miss Davis. Miss Davis, in clause 632-566 to the charge of prostitution, how do you plead, ma'am?
No contest.
Is there an agreement for Miss Davis?
Yes, there is, Judge. It is going to be for 6 months deferred adjudication, a $200 fine, court costs, 24 hours community service, an AIDS awareness course, and no contact with the Marriott Hotel at 323 Northwest Loop 410 in San Antonio, Texas.
I'm just going to make it all Marriott hotels in San Antonio, Texas. Is that okay, Mr. Perez?
That's fine, Judge.
And otherwise, is that your understanding of the agreement, John?
It is, Judge.
Ms. Davis, in clause 632-566, the court accepts your plea of no contest to the offense of prostitution. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt, place you on 6 months deferred adjudication probation. It says a $200 fine plus court costs, 24 hours community service, AIDS awareness course, or do you have no contact with Marriott hotels in San Antonio, Bexar County, Texas during the term of your probation? Anything further from the state or the defense on Ms. Davis?
Yes, Judge. My client is a resident of Harris County. She does not live here. Probation wanted me to make sure I mention that.
Ms. Gross, are you still with us?
Yes, Your Honor.
Can we transfer a 6-month case to Harris County, or does it have to be a year?
I believe it has to be 1 year.
Mr. Perez, with your permission and the state's permission, I want to make this a 1-year probation, and I will be happy to annotate she's eligible for termination at the 6-month time frame. But that's what I got to have, that 1 year to be able to transfer her probation to Houston. Is that agreeable to the defense?
It is. It doesn't look like it's agreeable to Ms. Davis. Ms. Davis, basically, it's still going to be 6 months. So as soon as you complete everything, still same thing. We filed the motion for early termination. That's so that you don't have to report into San Antonio. If we want to keep it at 6 months, you'd have to report into San Antonio. So it's
okay, but is there any way I can still get off earlier than 6 months?
Yes.
And let me jump in here, Mr. Perez. Mr. Perez and Ms. Davis, as far as I'm concerned, as soon as you get everything done, I'll be happy to early terminate you. You get it done in a month, we'll all be happy to cut you loose in a month. Ball's in your court. Is that fair?
That's fair. That's fine.
Is that okay with you?
Sounds good, Judge. We'll go ahead and go with the year.
All right, y'all are out of here. Thank you.
Thank you.
Judge.
Okay. Mr. Rivera, let's see what we're doing with Mr. Rivera. Got it. Okay, Mr. Rivera, on clause 673-075 to the charge of unlawfully carrying a handgun in a motor vehicle. How do you plead, sir?
No contest.
An agreement for Mr. Rivera?
Yes, Judge, there is an agreement. The agreement is to plead a cause number 673-075. It's a 12-month deferred adjudication, $500 fine, plus court costs, 80 hours of community service, forfeiture of a weapon to the DA's office, APSE course, gang eval, no contact with Union Pacific Railroad, and restitution to Union Pacific Railroad. The state will take into consideration cause number 657103.
Is there any restitution on this graffiti case 657103?
There is, Your Honor, yes.
Well, then how's it going to get paid if he's not on probation for it?
It's a,
What was that, Mr. Stateson?
Mr.
Oh,
State's doing too good a job. If there's restitution on this graffiti case, there's no legal way that I'm aware of, unless out of the kindness of Mr. Rivera's heart, he wants to pay off the restitution on the graffiti case. Mr. Stateson, you want to address that for me? That's a concern.
I had advised my client to say no contest to avoid any type of civil liability.
Well, I understand.
If
It still doesn't get the victim paid off is kind of where I'm coming from and the state should be coming from. How
I
much,
had advised,
do we know how much money's involved on restitution, if any? Maybe there isn't any. I don't know.
There is a restitution involved. I don't have that number in front of me. I can pull it up real quick.
Pull it up, please. I'll wait. If it's $50, that's one thing. If it's $5,000, that's something else.
I believe it's closer to around 2,000.
That sounds about right.
Okay.
$2,098.
All right. So is it the state's position that you're going to waive restitution and have this alleged victim of a graffiti incident not paid back for the damage to their building or their car or their whatever?
Or our position was to include the restitution in the plea.
Okay. Now we're getting somewhere. Is that your understanding, Mr. Stateson? Is that so? We're covered on that one. All right. Now
That is it. And I had advised my client of that. And we're going to ask the court for payment plans.
I got you. All good then. And state, this is the second or third time I've asked you this and I've not gotten an answer. You're making plea bargains to have primarily handguns, but firearms forfeited to the DA's office, which is ultimately going to end up in hundreds of firearms being forfeited to the DA's office. What is the DA's office going to do with all these forfeited firearms? And then why I'm bringing this up is because the last DA regime did the same thing and they sold them or they took them home and kept them, which is totally illegal. And I don't want that happening again. So I can't imagine that Joe would let that go on in your department. But have you asked anybody in your superiors on what's going on with these forfeited firearms?
Personally, I'm not aware of what happens to them once they're forfeited to the,
All right,
to
well,
the
you
DA's
and Mr.
office.
Lewis get together and find out who you need to talk to. I guess I can just call Joe if I need to and find out what's going on with that. If they've got a valid reason to have these things, that's one thing. But you obviously, I assume you understand my concern. Normally, we just give them to the defense counsel if they're willing to take them with the understanding they don't go back to the defendant, his family, or his friends. And then we dispose of them that way, and then they don't get destroyed if they're decent guns. What kind of gun is this, Mr. Stateson? Do you know?
It's a 9mm Smith & Wesson. And I had asked Mr. Villarreal if he had any objection for me requesting it. And my client was okay if it's awarded to myself.
And as the state has no objection to awarding it to the defense
All
counsel.
right, let's do that because I think that's much more clean. As additional attorney's fees, the court's going to order the weapon assigned to the defense counsel with the understanding it's not to be returned to the defendant, his family, or his friend. So that takes care of the gun deal. So let me go through this and make sure I touch all our bases, guys. Mr. Rivera, on cause 673-075, the court accepts your plea of no contest to defense of unlawfully carrying a handgun. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 1 year deferred adjudication probation. Assess a $500 fine plus court costs, 80 hours community service, the APSE stress management course, gang evaluation to see if you're a member of some colorful organization we're unaware of, or do you have no contact with Union Pacific Railroad? And is there restitution to Union Pacific Railroad also? Is that correct?
Yes, Judge.
And is that out of this case or out of the handgun case or out of the other case, the graffiti case?
It's out of the graffiti case.
All right. And restitution, any and all restitution stemming from cause number 657103 will be transferred to this case, and cause 657103 will be taken into consideration and dismissed. And is that correct, Mr. Stateson?
That is correct. And if I just may, I know you addressed the other client's pretrial conditions of bond. He's on a monitor. He has other conditions if those would be waived.
We're going to recall all pretrial conditions of bond and any warrants that may still be out there.
And if I could ask for, considering he's fairly young in his early 20s, he has restitution to pay, could there be the lowest supervisory fees on him?
Mr. Rivera and every other defendant in Bexar County County Court of Law number 6 has the lowest statutory supervisory fees assessed, $25 a month.
Thank you, Judge.
Isn't that right, Susan? So popular with the probation department. All right. Good luck, Mr. Rivera. Thank you, Mr. Stateson. Y'all are out of here.
Thank you.
All right. This is cause 669-211, State of Texas versus Adrian A. Jackson. Let's see what we're doing with Mr. Jackson. So State, you're not waiving anything. There are no motions. Is that correct?
That's correct, Judge.
Mr. Jackson, in cause 669-211 to the charge of driving while intoxicated with a blood or breath alcohol content of 0.15 or higher. How do you plead, sir?
Your Honor.
No contest. Is that correct?
No.
No contest, yes, Your Honor.
And I'm getting garbled transmission. Is that correct, sir? Yes.
Yes, Your Honor.
Thank you. And is there an agreement for Mr. Jackson, State?
Yes, Judge. The agreement is for 12 months in the Bexar County Jail, probated for 16 months, $600 fine plus court costs, 48 hours community service, DWI education, victim impact panel, CATSNP, and SSM for half the term.
And Mr. Staten, is that your understanding of the agreement for Mr. Jackson?
That's correct. And so the court's aware he already has Smart Start Mobile. He's had it for a while. He continues to make payments. He has an active warrant because of a blow into it, if that warrant could be lifted. And I would ask if you could personally write to have the court mark down at least a 90-day driver's license suspension. That way DPS doesn't suspend him up to the 2 years possible. I'd be very grateful.
State, is that okay with you? I don't have a problem with it.
No objection to that, Your Honor.
All right, so order a 90-day Texas driver's license suspension. Let me go through this and make sure we get all our T's crossed and our I's dotted. Mr. Jackson, in cause 669-211, the court accepts your plea of no contest to the offense of driving while intoxicated with a blood or breath alcohol content greater than 0.15. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 16 months, a $600 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, Smart Start Mobile Home Interlock at 4 blows a day for 8 months, which is 1/2 the term. And recall all pretrial bond and any possible warrants that are still out there. And we're going to order a 90-day Texas driver's license suspension. Anything further from the state of the defense on Mr. Jackson?
Nothing from the state.
Good luck, Mr. Jackson. Thank you, Mr. Stateson. We're good.
Thank you, Judge.
Thank you, Judge.
Betcha. Okay. What we're doing here.
Your Honor, if we could please do Miss Crane, she's having a little problem with the charge.
I'm sorry, say all that again. Who's having a problem?
Judge, it's Suzanne. I got here at the courthouse today with a fully charged computer and I didn't bring in my charger and I'm now sitting at about 19%. So
Yeah.
I was just concerned.
If you could try to do.
You want to go right now? We'll try to get you out of here before your computer crashes.
That
Please.
is the gist of it, please.
All right. This is cause 658-142, State of Texas versus Angel Perez. This is a motion to revoke community supervision represented by Ms. Suzanne Kramer. And Ms. Kramer, are you ready to proceed at this time?
Yes, Judge, and I would like for you to know that there are some family members in the Zoom that would like to speak to you on behalf of Mr. Pettis as well.
You're welcome to call any witnesses that you wish. If your computer does go out, Suzanne, I don't know if you've got access to a plug. You can't plug it in down there. Are you actually in the courtroom?
I'm in your courtroom. The charger is in the car. I think I'll be okay. I've got 19%. I think I'll be okay.
Well, worst case scenario, if you have to recharge or do something, then we'll come back and continue it to make sure you get all your witnesses called. All right, 658-142. Once again, this is a motion to revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. that purports to have both Mr. Perez and Ms. Kramer's signature on it. In fact, Mr. Perez, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Kramer, as attorney for Mr. Perez, is this your signature on this document?
Yes, Judge.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Mr. Perez, is this your signature on this document also, sir?
Yes, sir.
And Ms. Kramer, as attorney for Mr. Perez, is this also your signature on this document?
Yes, Judge.
Ms. Kramer, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes, Judge, with, some explanations.
Mr. Perez, in clause 658142, on the motion to revoke community supervision, how do you plead, sir?
Guilty.
Remember, Miguel, I was talking to you about it's a plea of true or not true?
Oh, yes, ma'am. True.
True.
So the court accepts the plea of true with an explanation. Would that be accurate, Ms. Kramer?
Yes, Judge.
Ms. Gross, would you please advise the court and the parties of the status of Mr. Perez's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Perez has performed very poorly on probation. He only has reported one time. He was placed on probation in October. We saw him in November and nothing since. He has made one payment of $102. He has a balance of $1,395, and he's currently delinquent $160. We have no record of any of his 48 hours community service having been completed. And we have no record of enrollment or completion of the DWI education victim impact panel or his CATSNP program being enrolled in or completed. He is currently on the Smart Start mobile device where he is testing 4 times per day. Since he has been on the device, he has had 20 skips and 6 high bracks. The 6 high bracks are November 4th, 0.046, November 10th, 0.026, November 25th, 0.059, November 27th, 0.023, November 28th, 0.035, and November 29th, 0.021. He has had positive drug tests, which include the one drug test that he did take. He was positive for 3 substances to include marijuana, cocaine, and alcohol. And he has 1 failure to submit. He has no criminal history. This is his first violation report, first MTR, and his officer is recommending revocation.
Okay, Ms. Kramer, what are you requesting?
Well, first of all, Judge, as far as Susan's saying they haven't seen him since November, the warrant went active December 3rd. He got put on probation October 28th. So, I mean, he did report the 1 month until the warrant went active. And of course, he hasn't completed anything because he's only been on probation for a month. Now, he honestly has not enrolled in anything either. I was talking to him. He's had some life issues that have caused him to do a bit of a backslide on this alcohol problem. But I met with him in a Zoom yesterday talking about what can we offer to you that would convince you to 1 month is not enough time for him to prove himself. And I think he's been in jail since well before Christmas, and he sat there throughout the holidays. I was hoping that possibly we could continue him, but with scram and or possibly an abuse, and of course bump his blows on the Smart Start device with a 0 tolerance, knowing that he's going to go for the full 6 months if he continues in this behavior. Obviously, he needs to enroll in his classes. I just think 30 days is not enough time for us to make a determination that we need to let him sit in jail for 6 months or however long that you would be inclined to let him sit there. I don't know how much time he's got, probably 2 or 3 weeks maybe under his belt by now.
Okay, did you say you had witnesses you wish to call?
They're not really witnesses, Judge. I basically wanted them here because so they can kind of let you know the support system they have in place as his family members for Miguel.
For the record, would you outline who's present?
Yes, it's Mark Perez. He's in there somewhere.
Hello, Your Honor.
There you are. Oh, yeah, sure. I remember you. And Alita Perez, she's up on my screen. She's at the top of the screen.
I've got,
Associate.
okay, and what relation is Mark Perez and Miss Alita Perez to the defendant, Mr. Michael Perez?
Marcus is, go ahead.
I'm his oldest brother and they're his sister and his mother.
Okay, thank you. Okay,
Um,
go ahead, Ms. Kramer.
Well, I didn't know if you wanted me to do it in a question answer or just because they don't have any, specific knowledge of any of this other than they can talk to you about what they will do now that they kind of see the situation that Miguel is in to give him a better support system.
Okay, you referenced that Mr. Perez was going through some life crisis or some sort of problems in his personal life that may have some bearing on his performance on probation. Can you clarify that for us?
I can. When I was speaking to him in the Zoom yesterday, I noted that, having had no issues, criminal issues of any kind, and then suddenly we're having all of this, something has to have happened. And he indicated that, he's basically a sad person. I said, well, no, we need more than that. And he indicated to me that I think like 2 years ago, he probably would be able to better tell you this. He and his girlfriend were expecting a child and they lost the child. And he says that kind of sent him into a tailspin. So he might need some, I don't know, mental health help as well.
Okay, state recommendation.
Our state's recommendation, since I'm hearing all this right now the first time, at least not in a while, I'm not sure if I've heard this before, but the state recommendation would be somewhat in line with defense's request. However, I would recommend a 30-day jail sanction and then continue on probation with the Scram device. I would also recommend adding the CATS IOP program as well.
Okay,
Yeah.
here's the textbook solution for Mr. Perez's problem is inpatient drug alcohol rehab. Now, the problem we have in Bexar County, I'm sure Ms. Kramer is familiar with, is that we are so backed up and so short of beds on the substance abuse treatment facility or the MIOP, mental illness offender facility. We can't get anybody in there in any reasonable amount of time. They would end up sitting in jail 60 to 90 days before
Longer.
a bed came open and they could go in for 120 days, which obviously I don't think any rational defense counsel or defendant in the world is going to say, oh yeah, I want to do that. But I'm offering him that. I really understand that may be silly of me to do, but that's what the textbook solution of his situation is he needs inpatient rehab. But I can't timely offer it to him because my hands are tied by the probation department's policy. Ms. Gross, you want to comment on that? Is that more or less accurate?
Yes, Your Honor. At this time, due to the situation across the nation involving COVID, the SATF is taking all of the felony as priority over the misdemeanor cases, which means that there are minimal slots available for misdemeanors, which is resulting in elongated wait times, sometimes greater than 90 days.
And Judge, I did discuss this with Miguel when I met with him in the Zoom that, if it comes down to that, I wouldn't recommend that he go that route because it's sometimes up to they're actually telling us it's an indefinite waiting period. They can't even give us a date when they could get somebody into a SATF, even in felony courts.
Understand. All right. Anything further from the state of the defense of Mr. Perez before I rule?
Did you want to hear anything from his brother or just know that they're there as a support system for him?
Here's what and they're welcome to comment. Let me tell you what my understanding of Mr. Perez's situation is. He's got a severe drug alcohol problem, primarily alcohol from what I see. We can't make him blow in the machines. We can't make him show up. We can't make him do anything. Now, I understand he may have some personal problems in life and he may even have some mental health issues, but we don't have the ability to help him with those right here, right now, so to speak. But if I can't get him to show up and blow in the machine and stop drinking, I don't know what I can do, but I'm happy to hear it. If they'd like to comment on that, that's my problem. That's my hurdle. And I only have limited tools in my toolbox.
Well, Judge, what I'm going to say, what I would always say is that this is, I don't think he really recognized, and I was the one who pled him, and maybe I wasn't clear enough how you are when somebody gets a motion to revoke in your court. I try to be pretty clear about that, but I think, he sat in jail now for 2 or 3 weeks. And with the Scram and even the antabuse, I told him I would even ask for antabuse to where it would make him absolutely so sick if he tried to drink I think he's deserve, we should at least give him one chance to show you that he can do it. And if he screws it up, then he knows he's going.
I think he's had plenty of chances. But if his family would like to comment any further, I'm welcome to hear them. Just call them.
Mark, would you like to speak to the judge about what you've been listening to?
Your Honor, on behalf of my family and I, we ask that your sentence be rehabilitative in nature first and punitive second. I personally ask you this as well, as I have been through a County Court 6 MTR in the past myself. And I found success completing and complying with the terms of my community supervision. I fear that a short prison sentence will land him in an unsupervised position in only a matter of months. We would prefer for him to continue to be supervised and given the chance to rehabilitate.
Thank you, sir. Anything further, Ms. Kramer?
No, Judge, thank you.
Stated, anything further?
Nothing further, Your Honor.
Mr. Perez, in cause 658-142, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bexar County Jail. What's the original fine amount, Susan?
It was $500, Your Honor.
$500 plus court costs, credit for time served, time and money to run concurrent. He certainly gets credit for at least the 22 days that he spent in jail. My understanding currently is the sheriff has a 2-for-1 or 3-for-1 quotient policy. I don't know what's applicable to Mr. Perez's situation, but I would urge the sheriff to give him the benefit of whatever the best quotient for him to get out of jail at the earliest time. Anything further from the state of the defense on Mr. Perez?
Nothing from the defense, Judge.
Good luck,
Nothing
Mr.
from the state.
And Ms. Kramer and Mr. Perez, y'all are dismissed. And thank
Thank you.
Thank Mr. Perez family for coming.
Thank you, Judge. I'll talk to y'all later, but we can leave.
Okay, that was Mr. Perez. We did Mr. Castillo. Mr. Dominguez, are you ready to go forward on Mr. Chavez's case?
Yes, Your Honor.
This is cause number 647-640, State of Texas versus Jonathan Chavez. This is a motion to revoke community supervision. The first document I have is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Mr. Chavez and Mr. Dominguez signatures on it. In fact, Mr. Chavez, is this your signature on this document, sir?
Yes, it is my signature, yes.
And Mr. Dominguez, as attorney for Mr. Chavez, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Once again, Mr. Chavez, is this your signature on this document also, sir?
Yes, Your Honor.
And Mr. Dominguez, as attorney for Mr. Chavez, is this also your signature on this document?
Yes, it is, Your Honor.
Mr. Dominguez, my understanding is that this is an uncontested motion to revoke community supervision. Is that correct?
That is correct, Your Honor.
Mr. Chavez, in cause 647-640, on the motion to revoke community supervision, how do you plead, sir?
I'm not quite sure what to say to that.
True. You plead true.
Okay, true, yes.
Court accepts a plea of true with an explanation, if that's okay with the defense. And that being said, Ms. Gross, would you please advise the court and the parties of the status of Mr. Chavez's probation at this time?
Your Honor, Mr. Chavez was reporting as directed up until November 19th, 2021, which is the last time we saw him. He has paid $242 towards his fees. He has a balance of $1,002 and he is delinquent $250. We have no record of any of his 48 hours community service having been completed, and we have no proof of enrollment or completion of DWI education, victim impact panel, or CATSNP. He has had 3 negative drug tests. He's currently on Smart Start Mobile, testing 4 times per day, and he has had 7 skip tests. His criminal history includes an arrest for assault bodily injury and possession of marijuana 0 to 2 ounces. And this is his first violation report, first motion to revoke. And his officer is recommending weekly UAs for 30 days.
How many total skip Smart Start mobile tests are we dealing with here?
7, Your Honor.
Over what period of time?
Give me 1 second. That would be between 24 September and 14 November. And I can look up his current stats if you want them since the last report date.
Look at those if you would, and let's see if we're still trying to do good.
Yes, sir. Give me just 1 moment, please. And mind you, this program for Smart Start is very slow, so it will take just a minute.
Worth every second. We need to know.
Okay, it looks like his last skip test was on November 1st, and then he did well and had another skip test December 14th. And then he has had multiple skip tests since December 20th, which I believe was a result of his incarceration on this MTR. And he has gone into lockout as of Christmas Day.
And being fully cognizant of the fact that you don't get positive alcohol tests on this machine unless you blow into it, and there have been various skips. We have no positive alcohol tests on Mr. Chavez's probation record. Is that correct?
That is correct, but he does have a long history of skipping tests, Your Honor.
Okay, and Abel, what are you requesting?
Your Honor, I am requesting that I believe probation wanted 30 days worth of UAs. I would certainly request that. I speak with the DA. They wanted to put the blows up to 6 times per day, and I am absolutely fine with that. I have spoken with my client. He realizes that he cannot take the in-home device as a joke. He has informed me that he is going to take it seriously from here on, and there won't be any mess ups.
All right, here's my problem. Whether he's blowing 4 times a day or 6 times a day or 107 times a day, he's still got to blow on the machine, and he's not doing that. So that being said, is he willing to go on a scram bracelet for 90 days? That would be $350 a month times 3. And if he does well on it, we'll take it off after 90 days and put him back on a Smart Start, or just waive it, depending on whatever the circumstances are. Is that something that y'all need to go in the breakout room and chat about, Mr. Dominguez?
I don't believe so. Mr. Chavez, are you good with that? And I assume, Your Honor, the scram would be in lieu of the in-home, so he replaces.
That's correct.
Okay.
Yes, that'll be all right with me, yes.
All right, I've got a plan. State recommendation, please.
The state recommends placing the defendant on scram, Your Honor.
Okay. And Susan, did you tell me that we have not started any of our programs? Does that sound right?
We have no record of him doing anything, Your Honor. No community service and no classes.
And Mr. Dominguez, is your client actually registered for anything or started any of these classes, or maybe he's in the middle of some of them that we don't know about?
That I am unaware of, Mr. Chavez. Have you started any of those classes?
No, I have not started any classes yet.
Are you working? Are you going to school? What are you doing? You're not doing anything for us.
Yeah, I'm currently working, and that's a bit of an issue at the moment. But after, obviously, I'm gonna have to put in more effort to try to schedule a a class for myself.
And where are you working, sir?
I'm currently a server at a Mexican restaurant.
Okay, Mr. Chavez, in clause 647-640, court accepts your plea of true with an explanation. I deny the state's motion to revoke your probation. Order you continued on probation with all prior requirements with a sanction of 30 days in the Bexar County Jail, credit for time served, judgment satisfied on the sanction. Altering and amending conditions, adding the Scram Cam ankle bracelet device within 10 days of your release from jail. Once that device is active, you can turn in your Smart Start mobile device. Putting you on weekly UAs. Show me 4 clean weekly UAs in a row. I'll put you back on monthly UAs. No hard feelings. I won't know you've done that. If you do that, you gotta let your lawyer know. He'll let me know. I'll confirm it with probation and we'll modify your probation. I want substantial compliance in all other areas within 10 days, which means any programs that you haven't registered for, you need to be registered for within 10 days. You may not start going to them yet, but you'll be registered for them and you know what you need to do. Is that clear for you, Mr. Chavez? You need any other more clarification on these things?
Just one clarification on that, Your Honor. Is it 10 days from today or 10 days from his release?
10 days from his release. Good point.
Okay.
And Judge, how many days minimum on Scram?
I think we said 90.
90, okay. And then you want him to resume the Smart Start once he gets out of jail until he is strapped on Scram, correct?
Do they have his Smart Start like in jail and part of his clothes and stuff? I mean, is that part of his property? They're going to give it back to him?
He's probably got it at home. So once he gets home, he starts blowing.
If he's got access to it, continue using the Smart Start device till we get you on the Scram bracelet. That's correct. All right. Any other clarification needs to be done, Mr. Chavez? You got any questions on any of this?
No, Your Honor. Everything's crystal clear.
All right. And Mr. Dominguez, I would ask you have about a 2-minute conversation with Mr. Chavez about how lucky he is and about how if there are any more problems, he's going to have a really bad day.
Absolutely, Your Honor.
All right. Thanks very much. Good luck, guys. Thank you.
Mr. Chavez, real quick. You will be receiving an email from me today. I know you're not going to be out of jail today. So as soon as you do get out of jail, you need to check your email and you're going to have your amended conditions. You need to sign those conditions, okay? And send them back immediately.
Okay.
That way we can get your referral over to the Scram so that, that they know that you're coming.
Okay.
Also, make contact with your officer. And are you aware of the fact that you have a new officer?
I am not aware of that, no.
All right. His name is Jorge Hinojosa. And your attorney can write that down and give that to you when you're out of jail. Call and touch base with him. Let him know that you were continued. And I'm going to send him an email as well. But you need to make sure to sign those conditions because if you don't, you're going to be right back here, okay?
Okay, we'll do.
All right,
Okay.
good luck to you, sir.
Thank you.
Mr. Dominguez, do you want to go into a breakout room with him?
Sure. And then may we be excused from there?
Sure.
Yes, of course.
Thank you.
All right, if you go into room 1, and I will put Mr. Chavez in room 1 as well.
All right, thank you.
You're welcome.
All right, Mr. Griner, give me about a 2-minute break here. I'll be right back.
Ross and Eddie, you know we're having that motion to modify bond after this. Okay.
Yep, I saw your email with the new motion and got a chance to.
And did you also get the D page and all of that the history and stuff that I had sent y'all yesterday?
Yes.
Okay.
Ross, I plugged up your mailbox again.
I see. I'm looking at it right now.
And that other one, you want to stand by not signing, correct?
Yeah. I'll leave that one.
He ain't gonna make it.
Are y'all giving offers already on the 11th docket?
Not yet. I don't think so. I haven't had a chance to look at it.
Because I've already gotten somebody off of it, which is kind of weird.
Oh.
Anyway,
Maybe it's an old offer or something. I don't know.
it must be. It must be.
It's usually my tomorrow agenda.
Yeah, well, mine is going to be getting rid of the 18th trial docket. I did not give up. I did not on the calendar put, I left the trials for the 31st because the order, or whatever it was from the new admin, was only till the 28th. It's probably.
I would be shocked if we actually make that.
I am too, but.
With how bad it is right now.
Because we
Like
don't
there's,
know.
yeah, true. No, yeah, it's all you can do until we hear something else. But
yeah,
I would be shocked if that does not change.
Oh, I know. I agree with you. But this is the new one. This is her first order. I don't know.
Yeah.
And Pat, did you appoint Alma on a Daniel?
On a Daniel?
Yeah, Espriella.
No, that one we did today already. It was Flavio because Alma was.
No, he's set next week.
Never mind. Go ahead, Judge. We'll talk about that later.
Okay, back on the record on cause 629-590 and 633-107. State of Texas versus Leroy Maldonado, represented by Mr. Randy Greiner. Mr. Greiner, are you ready to proceed at this time?
I had you muted on this.
All right, are you ready to proceed, sir?
Yes.
Very well. All right. The first
Okay, where is his client?
Should be in jail.
I don't see him.
Nope.
Did you lose another client, Mr. Greiner?
I guess so,
Hold
Judge.
on,
And I
I'm
put him in
getting
your
I'm
care.
getting- He's in the breakout room and
4. We were in 4.
get him into the main thing. I'm wondering if he took off. Let me go in and see what's going on, Your Honor.
All right.
Thought he was in there.
Hey, Mr. Maldonado, welcome back. We had you stuck out in the Bermuda Triangle at County Court 6, it sounds like.
Yes, sir.
Okay, back on the record. Once again, this is cause 629-590 and 633-107. State of Texas versus Leroy Maldonado, and these are both motions to revoke community supervision. Let me confirm that's true. Yeah. Okay, the first documents I'm looking at, one for each case, Mr. Maldonado. These documents are titled Defendant's Consent to Motion to Revoke Hearing by Video Conference. And on both these cases, cause 629-590 and 633-107. Are these your signatures on each of these documents, sir?
Yes, sir. It's true.
Thank you. And Mr. Greiner, as attorney for Mr. Maldonado, are these both your signatures, one on each document, one for each case?
Yes, Your Honor.
Thank you. Next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal. There is one of these documents in clause 629-590 as well as 633-107. Both are marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Maldonado, is this your signature on each of these documents, one for each case?
Yes, sir.
Thank you. And Mr. Greiner, as attorney for Mr. Maldonado, are these also your signatures, one on each document, one document for each case?
They are.
Thank you. Mr. Greiner, my understanding is both of these are uncontested motions to revoke community supervision. Is that correct?
That is correct.
Mr. Maldonado, on clause 629-590 on the motion to revoke community supervision, how do you plead, sir?
True.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Maldonado's probation in clause 629-590?
Yes, Your Honor. He was placed on probation in October, and we last saw him January 4th in jail. There's been no payments made on this case as the cases are running concurrent. This case only required a payment of $20, and that has not been paid. He is delinquent. We have no record of any of his 85 hours community service having been completed. We have no record of enrollment or completion of a theft class. He has had one positive drug test for opiates, which tested as hydrocodone. A review of his file did not reveal any proof of medical prescription, which would cause him to test positive for that. He has been ordered restitution, but that has not yet been investigated. This is his first violation report, first MTR. His arrest history includes evading arrest detention, evading arrest, felony theft, 1,500 to 20,000, which involved a prison sentence, 2 burglary of a vehicles, theft, 500 to 1,500, driving while license invalid, driving while license invalid enhanced, assault bodily injury married, 2 unauthorized use of a vehicle, both of which resulted in prison sentence, unauthorized use of a vehicle, driving while license invalid enhanced. Then he has 3 night mags for theft under 2,500 enhanced, which MOCA reflects that they are to be reduced and dismissed. And then, of course, he has the last burglary of a vehicle, which he is also currently on probation in this court. His officer is recommending that he be placed on weekly drug testing for 60 days. And
Everybody stop talking, please. Mr. Maldonado, would you turn your, there you go. I was just gonna ask you to turn your mic off because we're getting background noise. Thank you, sir. When we're ready to talk to you, I'd like you to turn it back on. Okay, Mr. Griner, what is your request, sir?
Judge, I would ask that you follow the recommendation by the probation department with regards to the situation that he took the unprescribed medication. It was actually prescribed, but for his daughter, the one that he's taking care of, she's 21 years old, was injured in an automobile accident. He's there to take care of her. He hurt his back while he was carrying her around the house. He's got limited medical insurance. So that was the excuse for that. Now, with regards to the classes, he was signed up for the classes. I'll ask him to speak about that. And he has paid $79 according to the probation report.
That's on the other case. That's on the other case. This case has no monies paid. He owes $20.
Aren't you running CC? Money's running CC?
They are running CC, but this one $20 charge is not a CC-able.
All right, I got it, Mr. Griner. Go ahead.
Okay, Judge. So he was signed up for the class and everything. He's got picked up in December. He's been there, I believe, about 15 days. So he also missed the holidays. But the family, he has a wife, and she's the one now taking sole care of the daughter and the 2-year-old granddaughter. We are asking that he be given an opportunity to at least take care of the burden that the accident caused his daughter to become and help out his wife, who should not be penalized.
And how old is Mr. Maldonado's daughter? I apologize.
21 years old.
He needs to help out his 21-year-old daughter. Is that what you're telling me?
That's correct, Judge. She was involved in an automobile accident and is severely injured. That's why when he hurt his back, that's why he took the medication to relieve the back pain from carrying her.
Okay. Anything further?
Yeah, I believe there's supposed to be a subsequent drug test done in December, and I don't see the results. So I don't know whether or not that would come clean or not, but my belief is that it would be.
It hasn't come back yet, I don't believe.
Now, if you would like, he can explain the situation with his daughter probably better than I can, Judge.
Sure, that'd be fine. Hey, Mr. Maldonado, would you, number one, we're all sorry that your daughter had this accident, injury stuff. If you'd let us know what's going on with that, we'd be interested in knowing.
Yes, sir. I've been taking care of her like for 7 months already. She flipped over 10 times. And I'm the only one who takes care of her and my 2-year-old granddaughter. I'm not a good speaker, but I was there for all this time. It's already going on 1 year already. I just want you to give me a chance and I'll do everything, possibly everything that I can, you know.
Were you signed up for those classes?
I signed up for the test class, and like I don't know how to read or nothing. I told the man I'll be back. I'm gonna go get the information, and he just told me to leave the paper there. So I just left. The paper. I signed some of it, half of it, because I was gonna complete everything in 15 days. I was gonna go report, but I was gonna do everything in 15 days. My community service, my class, I was gonna do everything in 15 days. All the 85 hours and all that. I was gonna do everything. But then they I don't know, they put me they gave me a warrant on the 21st or something. And that's why I'm here. But if you gave me a chance, I'll complete everything in 1 month so I could get it away with community service and the death class. If y'all gave me a chance. My family needs me out there. And I'm the only one who pays the bills.
What kind of job do you have? How do you earn money, Mr. Maldonado?
Roofing. I'm a roofer.
And anything further, Mr. Griner?
Nothing further other than we do ask that you follow along the recommendation of his probation officer. And point out that he was only on for 2 months when he got arrested again on the warrant.
Let me read probation's recommendation real quick. I got it. Okay, state recommendation on Mr. Maldonado in cause 629590, please.
State recommends to follow the probation recommendation.
Ms. Gross, what was the original fine on case number 629590?
Judge, the original fine was 600 and then you probated 300.
And then what was the original fine on cause 633107?
Same.
Okay, Mr. Maldonado on cause 629590, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assess a $600 fine plus court cost. Credit for time served, time and money to run concurrent. In this case, to run concurrent was 633107, and he gets credit for at least 25 days on cause 629590 and 27 days in jail on cause 633107, which will probably make his jail sentence somewhat shorter than normal. Anything further from the state of the defense on Mr. Maldonado on 629590?
Nothing from the defense.
Nothing from the state.
Cause number 633107, Mr. Maldonado, on the motion to revoke community supervision. How do you plead, sir?
Guilty, sir.
Court accepts the plea of true with an explanation. Is that okay, Mr. Griner?
Yes, Your Honor.
And is any variation on the theme of the facts of this case, Ms. Groves?
Judge, the only variation is in regards to the fees. He has paid $80 on this case. He has a balance of $1,442 and is delinquent $287. Otherwise, everything is identical to the previous case.
Basically, my intent is to do the same thing on this case I did on the other. Mr. Griner, do you have any comment on that?
No, Judge, we've made our argument.
State any further recommendation on 633107?
See, I don't believe so.
Mr. Maldonado, on cause 633-107, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bear County Jail, sets a $600 fine plus court costs. Credit for time served, time and money to run concurrent. This case to run concurrent with 629,590. My records reflect you get 27 days credit on this case. That being said, Mr. Griner will verify for you, Mr. Maldonado, that if I thought you were really a bad guy, you'd have 2 years stacked going on you right now. So I cut you as much slack as I possibly could under the circumstances. So best of luck to you. And I don't think you're going to be down there a whole lot longer. So good luck on all that. Anything further from the state of the defense on 633-107?
Nothing from the defense.
Nothing from the state. All right. Good luck, Mr. Maldonado. Thank you, Mr. Griner.
Thank you, Judge. May be excused.
And have we got Mr. Brendel and Ms. Ravel, or would you reset those? Oh, I see Mr. Brendel there, and I see Ms. Ravel there.
I'm here.
Ross, are you ready to go forward on Ms. Ravel on cause 635-213?
Yes, sir.
Ms. Ravel, can you turn on your camera for us, please, ma'am?
Yes.
This is cause 635-213, State of Texas versus Angela Ravel. This is a second amended motion to revoke community supervision. Mr. Ravel is represented by Mr. Ross Brendel. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both Ms. Ravel and Mr. Brendel's signatures on it. In fact, Ms. Ravel, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Mr. Brendel, as an attorney for Ms. Ravel, is this your signature on this document also, sir?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, well, it's mismarked. It says it's a plea bargain case, but it's not. What it is a revocation of the defendant's community supervision, possibly, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. So, Pat, administratively, that needs to be changed on that document. And is this your signature on this document also, Ms. Ravel?
Yes, Your Honor.
And Mr. Brendel, is this your signature on this document also?
Yes, Your Honor.
And Mr. Brendel, my understanding is this is an uncontested motion to revoke, second amended motion to revoke community supervision. Is that correct?
With an explanation of the allegations that she was arrested for another DWI. She does admit that she was arrested, but the legal literature clearly states that an arrest by itself is not a bad act, and she is innocent until proven guilty. So that is just with that explanation.
What I suggest is that the defense enter a plea of not true to condition number 1, because I don't think the state has a basis for proving up condition number 1. Do you, state?
Not at this exact moment, Judge.
All right, and then with the defense permission, I'll be happy. I'm not going to consider that, so to speak. I mean, I understand that there are other allegations, like she's still drinking, this, that, the other, but I suggest the defense just enter not true to that, and then true to whichever other ones you feel like are actually true, and then we'll.
What was the second allegation?
Alcohol consumption.
In other words, they filed on her on this motion to, second amended motion to revoke community supervision. Violated condition number 1, meaning she was rearrested and charged with driving while intoxicated, and condition number 2, meaning that she was consuming alcoholic beverages. So obviously I can consider that if in fact she was, and you don't influence me differently, that she was drinking, and that's what all I'm going to do on that. I'm not worried about the second offense. Y'all can get your day in court on that at some future time.
And then additionally, there on the amended MTR that was filed yesterday, there are 2 additional failure to submit to drug testing.
Okay. Anyway, so Ross, with regard to the second amended motion to revoke community supervision, my understanding is the defense is willing to enter a plea of not true with an explanation to condition number 1, which is the new arrest, and true with an explanation to the remainder. Does that sound right?
Can you put me in a room with Ms. Revel just to clarify that?
Absolutely.
Thank you.
Gesundheit.
Thank you. I'm hoping it's just the cedar fever.
So Ms. Ion, have you had to hang around all afternoon listening to us to make sure you could jump in here at the appropriate time?
I'm sorry, were you talking to me?
I said, did you have to listen to all this stuff we've been going through for 2 hours to find the appropriate time to jump in, or did you just come in at 4?
Oh, Miss Pat has my cell phone. She texted me. She let me know. She's like, you don't have to wait around, which is nice. Thank you so much.
Perfect. All right. Well, we'll get to you.
Though I'm sure it was interesting.
Pat, your mic's turned off.
Okay, I've got 2 ADA's coffee.
And a PO with frogs.
I think it's just allergies. It's not it happens to me every time this year, and my head gets all cloudy and just bleh.
Yep.
Still got to go get tested.
Ross has the plague. Ross has the plague.
Right.